You're watching the presentation, a case review of HUD versus Rucker 2002. I am Stephen Shiao. This presentation is prepared for the Business Law Class 2013 Calmat Spring, instructed by Professor Samuel Tang. In brief, 4 elderly tenants brought this case to the court after the Oakland Housing Authority (OAHA) commenced eviction against the tenants of alleged violations of lease provisions, which asking the tenants to assure that the tenant, any member of the household, or any other person under the tenant's control should not engage in drug-related criminal activity on or near the premises. After OHA initiated the eviction proceedings in the state court against Rucker, Hills, and Walkers, they commenced action against OHA in the Federal District Court, challenging the Department of Housing and Urban Development as the interpretations of the federal statute requiring for evictions for criminal activities in their department. The Rucker then commenced action against OHA in Federal District Court, and District Court issued a preliminary injunctions enjoined the OHA. Then the panel of the Court of Appeal reversed the decisions. Then the full Court of Appeals reversed the panel. Then in the very end, the HUD appeals to the U.S. Supreme Court. This is the procedure's history. There are 3 issues or questions. The first is what caused the evictions. Since the HUD was requested that the tenants needs to assure that any member of the household or any other person under the tenant's control should not engage in drug-related criminal activities on or near the premises. Then the authority was that the Public Health and Welfare Code, which does not authorize the eviction of the innocent tenants, and then decided who is the innocent. Also, there is another argument of the statute of whether this is constitutional. If the statute does not authorize such evictions, then the statute is unconstitutional. Now let's go over this case in detail. In this case, Ms. Rucker, who was listed on OAHA, which is the Oakland Housing Authority, on the lease as a resident, but who was found with cocaine and crack cocaine pipe 3 blocks from Rucker's apartment. Then Mr. William and Mrs. Hills both were residents on the lease of the OHA. They were caught in the parking lot smoking marijuana. And the third one was Mr. Walker, another OAH resident, and 2 others were found with cocaine in Walker's apartment. In the summary, Rucker was found with cocaine 3 blocks from Rucker's apartment, and William and Hill were smoking marijuana, and Walker found with cocaine. Oakland Housing Authority initialized the eviction on Rucker, Hills, and Walker. Then Rucker filed challenging HUD interpretation of Fed statute requiring eviction for criminal activity, and then Rucker argued that statute and HUD regulation interpretation result in eviction of innocent people, which is unconstitutional. The holding was that the criminal activity did not take place at the property. That's the first one. And the second one was criminal records cannot be used as a criminal activity evidence. So, in response to OHA actions, the tenants filed another lawsuit in the district court, arguing that, contrary to the HUD's interpretation, the Public Health and Welfare Code does not authorize evictions of innocent tenants. The tenants also argued that if this statute does not authorize such eviction, then this statute is unconstitutional. Now, let's go over the dispositions. The court decided in favor of the defendant final disposition of the case. According to HUD, the tenant should not be excluded from the contractual responsibility by arguing that the tenant did not know or could not foresee or could not control behavior by other occupants of the unit. The HUD's interpretation of the Public Health and Welfare Code was consistent with the statute, and that statute, so interpreted, was constitutional. The court determined that the tenants could be legally evicted for any drug use by household member or guest near or on the apartment premises. Furthermore, that the Congress wants to ensure that the safety of the public housing, which allow eviction for criminal activity in leased property, even when the tenants were at or not at the premises. This brings that to the result, no constitution issue as long as the proper process under the state law for evictions are followed. The tenant should not be excused from the contractual responsibility by just arguing that the tenant did not know or could not foresee or could not control the behavior of other occupants of the unit. So my opinion in concurring was that the Congress, in constructing the relevant section of the Public Health and Welfare Code, the intention was to ensure that the tenancies were not terminated except a serious repeated violation of the terms and conditions of the lease or for any other good cause. Understanding this, the low-income tenant was facing a great problem when evicted. So, but in the very end, conclusion was that the tenants could be legally evicted for any drug use by household members or guests near the apartment or on the apartment premises, which is fit the welfare and the health code. Also, it doesn't violate any constitutional rights.